Welcome back to LexTalks Legal Topics Simplified.
Yeah.
One of the things I find fascinating about law is how it's so deeply connected to history and society.
Right.
Today's topic is a perfect example of that.
Yes?
Reservation in India.
Yeah, it's a topic that often sparks, heated debates.
Yeah,
But understanding its legal framework is crucial for anyone studying law in India.
exactly. So for all you aspiring lawyers out there, let's break down this complex system.
Okay.
What exactly do we mean when we talk about reservation?
So at its core, reservation is a form of affirmative action.
Okay.
It's designed to level the playing field by providing opportunities to groups that have faced historical discrimination.
Right.
Think of it as reserving a certain percentage of seats
Uh-huh.
in educational institutions, government jobs, or even political bodies for these specific groups.
And this isn't something new, right? I was reading that the concept of reservation in India dates back way before independence.
You're absolutely right. One early example is from 1902 when Chhatrapati Shahu, the Maharaja of Kolhapur, introduced a system reserving 50%. Wow.
For non-Brahmin and backward classes.
50% back then. That's a bold move for that time. But how did this evolve into the system we have today?
Well, after India gained independence, Dr. B.R. Ambedkar,
Yeah.
a key figure in drafting the Constitution and a champion for social justice,
Right.
played a crucial role in shaping the modern reservation system. He understood that to truly achieve equality, certain groups needed a leg up,
Right.
a way to overcome the disadvantages they had faced for centuries.
So it's not just a policy, it's literally enshrined in the Constitution itself.
Precisely Articles 15.4, 16.4, and 335 of the Indian Constitution form the bedrock of reservation policy. They empower the state to make special provisions for the advancement of what we call backward classes.
Okay.
Think of it like this. The Constitution recognizes that equality doesn't always mean treating everyone the same.
Right.
Sometimes it requires giving certain groups additional support to achieve true fairness.
That makes sense now when we talk about backward classes.
Yes.
What are the specific categories included in the reservation system? There are three main categories.
Okay.
Scheduled castes, SCs, scheduled tribes, STs, and other backward classes, OBCs.
Okay, let's break those down. Could you tell us a bit more about each category and the percentage of reservation they are entitled to?
Certainly, scheduled castes, often referred to as SCs, have a 15% reservation.
Okay.
This category is rooted in the historical context of untouchability and the severe discrimination they faced for centuries.
Right.
Then there are the scheduled tribes, or STs, who have a 7.5% reservation.
Okay.
This recognizes their distinct cultural and social identities and the fact that they often reside in geographically isolated areas facing unique challenges.
Okay, that makes sense. What about the OBCs? It sounds like a pretty broad category.
It is the identification of OBCs, and their 27% reservation quota came about much later after the landmark Mandel Commission report in 1992.
Okay.
This report was instrumental in identifying numerous groups based on their social and educational backwardness and recommending reservations for them.
So reservation isn't just about caste. It also takes into account social and educational backwardness.
Correct.
But I imagine even within these categories, there are wide variations in terms of economic status.
You're right. That's where the concept of the creamy layer comes in.
Okay.
It's a mechanism to ensure that the benefits of reservation reach those who truly need them.
Wait, creamy layer. Could you elaborate on that a bit? I'm not sure I fully grasped the concept.
Think of it like income-based scholarships.
Okay.
Not everyone within a disadvantaged group needs the same level of support.
Right.
The creamy layer concept excludes the more affluent members within the OBC category who've already attained a certain level of social and economic advancement.
Right.
It's a way to prevent the concentration of benefits among a select few.
So it's a safeguard to ensure that reservation doesn't become a tool for the already privileged
Exactly.
within those backward classes. Now, I also came across something called the EWS reservation. Is that a new category?
Yes, it's a relatively recent addition with a 10% quota for economically weaker sections, or EWS. This is aimed at supporting economically disadvantaged individuals, even from the general category, recognizing that economic hardship can exist across different social groups.
So the reservation system acknowledges that poverty and disadvantage aren't limited to specific castes.
Exactly. It's an evolving system trying to address the complexities of inequality in India.
With so much at stake, I'm sure there have been numerous legal challenges to the reservation system over the years. Are there any landmark Supreme Court judgments that law students should be aware of?
There are quite a few, but two stand out.
Okay.
The first is State of Madras v. Champakam Rajan from 1951. This was the first major challenge to reservation and actually led to the addition of Article 15.4 to the Constitution.
Interesting.
It highlights the evolving nature of the Constitution itself in response to societal needs and judicial pronouncements.
That's interesting. So even the Constitution has been amended to address issues arising from reservation.
Mm.
What about the second landmark case?
The second is the Indrasalni v. Union of India case from 1992, also known as the Mandal case.
Oh.
This one upheld the 27% OBC reservation, introduced the creamy layer concept we discussed earlier,
Right.
and most importantly set a 50% cap on the total reservation.
A 50% cap. Why was that necessary?
The court wanted to strike a balance
Okay.
between addressing historical injustices and ensuring that merit and efficiency weren't completely sidelined.
Yeah.
This cap essentially means that at least half of the seats must be filled based on open competition.
So it's a way to ensure that merit still plays a significant role in the selection process. Now, let's talk about how reservation actually plays out in educational institutions. Does it apply to both government and private institutions?
Yes, it does. Initially, reservation was only for government institutions, but that changed with the 93rd Amendment Act of 2005, which extended it to private educational institutions as well.
So even private colleges and universities have to adhere to the reservation quotas?
They do, although there's been some debate, particularly regarding minority-run institutions
Okay.
and the extent to which they should be subject to these policies.
I can imagine that's a complex legal issue, balancing the rights of minority institutions with the goals of reservation now. Besides SEs, CABAs, OBCs, and EWS, are there any other groups that benefit from reservation in educational institutions?
Yes, the Persons with Disabilities Act of 2016 mandates a 5% reservation for persons with benchmark disabilities in all educational institutions receiving government aid.
So the reservation system aims to address not just historical injustices,
Yeah.
but also the needs of people with disabilities. That's pretty comprehensive.
It is, and remember, the system isn't static. It's constantly evolving through legal challenges, amendments, and societal debates.
That makes sense. Now turning to state services, how does reservation work in the context of government and public sector jobs?
It works in a similar way to educational institutions,
So,
ensuring representation of different categories at various levels of the workforce.
so how do they practically implement these quotas? I mean, how do they make sure the right number of people from each category are actually hired?
They use a system called rosters.
Roster.
Think of them as charts that help government departments track and maintain the proportionate representation of different reserved categories in their workforce.
So each department has to keep track of these quotas and ensure they're being met when hiring new employees. That sounds like a logistical challenge.
It can be, and it's not without its controversies.
Right.
There have been legal challenges related to reservation in promotions as well, adding another layer of complexity.
It's understandable. Whenever you have a system that impacts so many lives, there are bound to be debates and differing opinions. What are some of the main criticisms and controversies surrounding the reservation system in India?
Well, one of the major criticisms is that while aiming to promote equality reservation might inadvertently perpetuate caste divisions,
Okay.
critics argue that constantly categorizing people based on their caste keeps those very divisions alive.
So the argument is that by constantly labeling and categorizing people based on their caste, it reinforces the very system it aims to dismantle.
Exactly. Another concern is about balancing social justice with meritocracy. Some argue that reservation can sometimes lead to the selection of less qualified candidates solely based on their caste or economic background,
Right.
potentially compromising quality and efficiency.
It's a difficult balance to strike, ensuring fairness and representation while also maintaining standards of excellence. Are there any other arguments against the reservation system that we should be aware of?
Some argue that the focus on caste-based reservation might distract from addressing other crucial forms of inequality, like those based on class, gender, religion, or disability.
So the question is whether reservation is broad enough in its scope or whether it needs to evolve to encompass a wider range of disadvantages.
Precisely. There's also the concern that long-term reservation could potentially disincentivize individuals from striving for excellence knowing they have a safety net regardless of their performance.
Right.
Critics argue that this could lead to complacency and hinder overall development.
That's a valid point. Does reservation truly uplift marginalized communities in the long run, or does it create a sense of dependency and potentially hinder individual initiative?
That's the crux of the debate. It's a complex issue with valid points on both sides.
It seems like understanding these nuances is crucial. For anyone studying law in India, It's not just about knowing the legal framework, but also grasping the various arguments for and against the system and how it plays out in real-world scenarios.
Absolutely. And that's what we'll be exploring further in our next segment. We'll delve into some real-life legal cases that highlight the complexities and challenges of reservation in action. Stay tuned. Welcome back to LexTalks. Now that we've established the basics of reservation, let's dive into the practical side of things.
Perfect, because I'm sure our listeners are eager to see how these principles play out in real-life legal scenarios. So hit us with a case
Okay.
that really highlights the complexities of reservation in action.
Let's discuss the case of M. Nagaraj v. Union of India from 2006.
Okay.
This case dealt with the controversial issue of reservation in promotions for government employees.
Promotion's always a sensitive topic, even without the added layer of reservation.
Exactly.
What was the main point of contention in this case?
A group of general category employees challenged the constitutional validity of Article 16(4)(a), which allows for reservation in promotions for SCs and STs.
Right.
They argued that it violated their right to equality.
So it wasn't about reservation in initial appointments,
Right.
but whether it should extend to promotions within the government hierarchy. What did the court decide?
The Supreme Court upheld Article 16(4)(a), but added some important safeguards.
Okay.
They stated that the state must demonstrate compelling reasons for implementing reservation in promotions.
Compelling reasons. That sounds like a high bar to clear.
It is.
What did the court consider as compelling?
The court outlined 3 key factors.
Okay.
First, the state must prove the backwardness of the class being considered for reservation in promotions.
Okay.
Second, they have to show that the class is inadequately represented in that particular cadre of public employment.
Right.
And third, the state must demonstrate that providing reservation wouldn't compromise the overall efficiency of administration.
So it's not enough to simply say, this group has historically faced discrimination, therefore they deserve reservation in promotions. The state needs to back it up with data and evidence.
Exactly. This judgment was crucial because it clarified that merit and efficiency cannot be completely ignored,
Right.
even when implementing affirmative action policies.
It's interesting how the courts have to constantly strike a balance between addressing historical injustices and ensuring a level playing field for everyone. Are there any other cases perhaps related to education that illustrate these complexities?
Let's look at the Ashok Kumar Thakur v. Union of India case, decided in 2008.
Okay.
This one revolved around the 93rd Amendment Act, which, as we discussed earlier, extended reservation to private educational institutions.
Right. That amendment sparked a lot of debate back then. What were the main arguments against it?
The petitioners argued that the amendment infringed upon the autonomy of private institutions.
Okay.
Particularly their right to establish and administer their own affairs, as guaranteed by Article 31.
Oh, okay.
They felt it was an overreach of the state's power.
So it was essentially a clash between the state's effort to promote social justice and the right of private institutions to maintain their autonomy. What was the court's verdict?
The Supreme Court upheld the 93rd Amendment, but with certain limitations.
Okay.
It clarified that minority educational institutions are exempt from this provision.
That's a crucial point. Minority institutions have their own set of constitutional protections.
Indeed, the court also emphasized that private institutions retain the right to regulate their own admissions process and set their own fee structure.
So even though they have to implement reservation, they still have some control over their admissions policies.
Precisely, the court aimed to strike a balance between promoting social justice and respecting the autonomy of private institutions. However, they made it clear that this autonomy can't be used to undermine the objectives of the reservation policy.
It's a fine line to tread. It seems like every judgment related to reservation adds another layer of nuance to this already complex issue.
You're absolutely right. Now, moving beyond these landmark cases, are there any specific legal provisions that law students should be familiar with when dealing with reservation, especially in education?
That's a great question. It's important to remember that the law isn't just about big landmark cases.
Right.
It's also about understanding the specific provisions and how they impact everyday life.
Exactly. One important piece of legislation is the Persons with Disabilities Act of 2016.
Okay.
Specifically, Section 32 of this act mandates a 5% reservation for persons with benchmark disabilities in all educational institutions receiving government funding.
So for those interested in disability law, this act is essential reading, especially when considered alongside the constitutional provisions on reservation.
Absolutely. And speaking of constitutional provisions, let's not forget that Article 15.4, which we discussed earlier,
Right.
specifically empowers the state to make special provisions for the advancement of any socially and educationally backward classes of citizens.
Right. That's the article that lays the foundation for the entire system.
Exactly. Now, remember how we talked about regional variations in reservation policies?
Yes.
Well, this is where it gets interesting. Different states can and do interpret and implement reservation differently,
Yeah.
leading to a complex patchwork of policies across the country.
That's right. We touched upon that earlier. Any specific examples that highlight these state-level variations?
Tamil Nadu is a classic example. They have a 69% reservation quota in state government jobs and educational institutions, much higher than the 50% cap set by the Supreme Court for central institutions.
Whoa, 69%. How can they exceed the 50% cap set by the Supreme Court?
It's a unique situation. Tamil Nadu's higher reservation policy is based on a long history of social justice movements and specific socio-political factors within the state.
Right.
They even had to amend their state constitution to protect these provisions from legal challenges.
So it's almost like an exception to the general rule allowed due to the specific context of the state.
You could say that it shows that reservation isn't a one-size-fits-all concept. It's tailored to the unique realities of different states now, on the other end of the spectrum. Let's look at West Bengal.
Okay, what's unique about West Bengal's reservation policy?
They currently have a 7% reservation for OBCs in state government jobs,
Okay.
which is significantly lower than the 27% mandated at the central level.
That's quite a difference. So even within the same OBC category, the percentage can vary drastically depending on the state you're in.
Precisely, it demonstrates the complexity of reservation and how it's not a monolithic concept for law students. Understanding these regional variations is just as crucial as knowing the central laws.
Absolutely.
Hmm.
It seems like you need to be a detective to navigate the world of reservation in India.
It can feel that way sometimes.
But this deep dive is really helping us connect the dots. Now we've covered educational institutions and government jobs.
Yes.
But what about reservation in other spheres of public life? Does it apply to politics as well?
It does. Reservation extends to political bodies, ensuring representation of marginalized communities in parliament, state legislatures, and even local government bodies like panchayats.
That makes sense. Having a voice in the political process is crucial for any group to advocate for its interests and influence policies that affect them.
Exactly. Reserved seats help ensure that marginalized communities have a say in the laws and policies that shape their lives. But as you can imagine,
Yeah.
reservation in politics is not without its critics.
I bet it's such a politically charged issue. What are some of the main criticisms leveled against reservation in politics?
One common argument is that it can lead to vote bank politics,
Okay.
where politicians focus on appealing to narrow caste-based identities rather than addressing broader national interests.
So the fear is that it might create divisions rather than unity, with politicians catering to specific communities instead of working for the good of everyone.
That's one concern. Another criticism is that reserving seats might sometimes prevent more capable leaders from other communities from emerging, potentially hindering the overall quality of leadership.
I see the point. It's a delicate balance, ensuring adequate representation for historically marginalized communities while also making sure the system remains meritocratic and serves the interests of everyone.
A very delicate balance.
But these are precisely the kinds of complex issues that legal professionals have to grapple with.
You're absolutely right. Understanding the historical context, the legal framework, and the various arguments for and against reservation is crucial for any aspiring lawyer.
It's not just about rote learning the laws, it's about critically analyzing them, understanding their impact, and engaging in informed debates.
Precisely. And before we move on to the future of reservation in India, I think it's crucial to acknowledge something often overlooked in these legal discussions, the human element.
That's an excellent point. We've been talking about articles, amendments, and judgments, but at the end of the day, these policies impact real people's lives in profound ways.
Exactly. It's essential for law students to go beyond the legal texts and engage with the lived experiences of individuals from both reserved and general categories. Hearing their stories, understanding their perspectives, can provide a much deeper understanding of how reservation plays out in the real world.
I completely agree. Law isn't just about abstract principles, it's about people. And for aspiring lawyers, listening to those directly affected by these policies can be incredibly insightful. What kind of perspectives should law students be seeking out to develop a more holistic understanding of this complex issue.
For instance, they could talk to students who have benefited from reservation policies to understand how it's impacted their access to education and career opportunities.
Right.
Or they could interview professionals from general categories who have faced challenges or perceived unfairness due to reservation in their fields.
Hearing these personal stories can really bring the issue to life, helping us move beyond abstract legal arguments and connect with the human side of this complex and evolving system.
It's about recognizing that everyone has a story, a unique perspective shaped by their experiences with the reservation system, and for future legal professionals engaging with these diverse narratives is crucial to shaping just and equitable policies.
That's a powerful thought. Understanding the law is important, but understanding its impact on people's lives is even more crucial.
Couldn't agree more.
We've covered a lot of ground in this deep dive into reservation in India, from its historical roots and legal framework to its real-world applications and the controversies surrounding it.
It's a multifaceted issue with no easy answers, and as you said, it's constantly evolving.
Exactly, which brings us to a crucial question. Where do we go from here? What does the future hold for reservation in India?
Well, that's a question that policymakers, legal experts, and society as a whole are grappling with. There are many potential paths forward,
Yeah.
each with its own set of challenges and opportunities.
So what are some of the key areas where we might see changes or evolution in the reservation system?
One key aspect that needs continuous evaluation is the criteria for determining backwardness. As society progresses, our understanding of social and economic disadvantage evolves. The question is,
Yeah.
should the criteria for reservation remain solely focused on caste and economic factors, or should it expand to encompass a wider range of socioeconomic indicators?
That's a crucial question, as we've discussed.
No,
Disadvantage isn't always so clear-cut. It's often a complex interplay of various factors.
Exactly. There's growing recognition of the concept of intersectionality, which highlights how factors like gender disability, geographical location, and even family size can intersect and create unique forms of disadvantage.
Right.
For example, a woman from a scheduled caste living in a remote village might face a different set of challenges compared to a man from the same caste living in an urban area.
So the criteria for identifying those deserving of reservation might need to become more nuanced to capture these complexities.
Precisely. And alongside refining the criteria, there's also the issue of implementation. How can we make the reservation system more efficient, transparent, and less susceptible to manipulation? Fake caste certificates and individuals exploiting loopholes are serious concerns that need to be addressed.
Ah, yes. We need to ensure that the benefits of reservation actually reach those they are intended for.
Absolutely. Technology could play a crucial role here.
Ah.
Digitizing records, streamlining verification processes, using data analytics to identify patterns of misuse.
Right.
These could all contribute to creating a more robust and accountable system.
It sounds like the future reservation might involve a delicate balancing act
Yes.
between expanding its scope to encompass a wider range of disadvantaged groups and tightening its implementation to prevent misuse.
You've hit the nail on the head. It's a complex equation with no easy solutions.
Now, we can't talk about the future of reservation without addressing the elephant in the room, the 50% cap.
Mhm.
Do you think this limit set by the Supreme Court will change anytime soon?
It's a highly contentious issue. Some argue that the 50% cap, while well-intentioned, might be too restrictive in today's diverse and complex society. They point to the increasing demands for inclusion from various groups and the addition of the EWS category as reasons to reconsider the limit.
So the argument is that the 50% cap, while aimed at safeguarding meritocracy, might be hindering the inclusion of deserving groups who fall outside this limit.
Exactly. But on the other side of the debate, there's the concern that exceeding the cap could further dilute meritocracy and create a system where qualifications take a backseat. Finding that balance, ensuring inclusivity without compromising quality and efficiency is the crux of the matter.
It's a tightrope walk, for sure. Now, another question that often comes up is the duration of reservation. Was it intended to be a permanent fixture or a temporary measure to bridge a historical gap?
That's a question that has sparked intense debates for decades. The original idea was that reservation would be a temporary measure to uplift disadvantaged communities and create a level playing field. The assumption was that after a certain point, these communities would have caught up and reservation would no longer be necessary.
But is that a realistic assumption given the deeply entrenched nature of social and economic inequalities in India?
That's the point of contention. While reservation has undoubtedly uplifted millions, simply removing it might not lead to genuine equality overnight. The legacy of historical discrimination and systemic disadvantages can't be erased so easily.
So some argue that reservation needs to continue until we reach a point where opportunities are truly equal for everyone regardless of their background.
Exactly. But others believe that a more sustainable approach would be to focus on empowering these communities through other means like targeted educational and economic programs alongside reservation.
So maybe a multi-pronged approach is the way forward, tackling both the symptoms and the root causes of inequality.
That's likely the most effective strategy in the long run. Addressing issues like poverty, lack of access to quality education, and discrimination in various spheres of life is crucial for achieving lasting equality.
This brings us to a fundamental question. Can we envision a future India where reservation is no longer necessary?
It's a question that speaks to the very heart of what kind of society we want to create, a truly equitable and just society where everyone has equal opportunities regardless of their background. That's the ideal we should strive for.
But is that a utopian dream, or is it a goal we can realistically achieve?
It's a journey that requires not just legal and policy changes, but a fundamental shift in societal attitudes. We need to break down deeply ingrained prejudices and biases, foster a culture of inclusivity and respect, and ensure that everyone is judged on their individual merit and potential, not their caste, religion, or economic status.
So it's about changing mindsets, not just laws. It's about creating a society where everyone feels valued and has an equal chance to succeed.
Precisely. And that's where the role of law students, future legal professionals, becomes incredibly important. You have the power to shape not just the legal framework, but also the discourse surrounding reservations.
By advocating for just laws, challenging discriminatory practices, and promoting a culture of inclusivity and equality.
Absolutely. You can be agents of change, ensuring that the reservation system evolves in a way that truly serves its intended purpose to create a more just and equitable India for everyone.
That's a powerful message. It's a reminder that the law is not just about interpreting text, but about shaping a better future.
And on that note, it's time to wrap up this deep dive into reservation in India.
Thank you for joining us on LexTalks. We hope this exploration has given you a deeper understanding of this complex and ever-evolving issue.
Remember, understanding the law is just the first step. The real challenge lies in using your knowledge to build a more just and equitable society.
If you enjoyed this episode, don't forget to subscribe to LexTalks on your favorite platform for more insightful legal discussions. Until next time, keep learning and keep striving for a better tomorrow.